Hi, y'all, and welcome to a pop-up live stream this afternoon. Well, as we know, Karen Reed had a hung jury in her case. She was accused of murder, of running her car backwards into her boyfriend, leaving him to die in the snow. There were three charges against her, actually. One was second-degree murder, by far the worst, that could result in the most years in prison. She was also charged with leaving the scene of an accident causing death and manslaughter while operating a motor vehicle under the influence. There was a hung jury in her case. The judge then declared a mistrial, and we are headed for trial number 2. But in the week after Karen Reed's trial went forward, jurors came forward and said they had actually agreed with each other about two of the charges. Specifically, they had all agreed that Karen Reed was not guilty of second-degree murder, that she was also not guilty of leaving the scene of an accident causing death. So for those two charges, they were off the table. The only thing they were truly deadlocked on, some of the jurors said, was manslaughter. So at that point, the jury could have returned a verdict on just those two counts, but they did not know that, and could have left the other one for another jury to decide. But since they didn't know that, that didn't happen. This was a devastating blow for the Reed team to realize, because they were so close to acquittal on the most serious count by far, second-degree murder. So they asked the court to dismiss those charges, and the court said, no, I'm not going to dismiss those charges. They appealed to the Massachusetts Supreme Judicial Court, which is the name for Massachusetts' Supreme Court, and they have now ruled against Karen Reed. Karen Reed will be going back to trial, and the Commonwealth can try her on all counts, including second-degree murder. There will not be a decision made that she's acquitted of those charges because the jury agreed. So we're going to talk about why this happened, even what it means, what we're talking about. We're going to break this down very simply. I'm going to show you some video clips of exactly what happened in the trial. I'm going to show you what the Supreme Court ruled, so you'll fully understand exactly what's happening and why the Supreme Court ruled this way. And we'll also, of course, talk about what this means for Karen Reed, what's going to happen next for her. So let's get started by looking at the document that was dropped today. This is an opinion from, and I'll roll it up to the first page. This is an opinion that was issued by the Massachusetts Supreme Judicial Court in Karen Reed's case. And we're going to read, not all the pages will be this highlighted, don't worry, but I wanted to give you an overview, and then we're going to go into specifics. Then we're going to do some video clips to show you what happened, and then we'll finish up this document. So let's make sure we have it set right. Okay, there we go. All right, the defendant's motion to dismiss, and that means Karen Reed. Karen Reed's motion to dismiss and this petition, what Karen Reed is asking for, rely on post-trial accounts from several jurors. That means stuff that jurors said after the trial was over, after they've been sent home. These accounts suggest that during deliberations, the jury unanimously agreed the defendant was not guilty on two of the three charges and were deadlocked only on the remaining charge. The defendant argues that a mistrial was thus not manifestly necessary because the judge could have requested a partial verdict from the jury before discharging them. The defendant further asserts that these post-trial accounts show she was, in effect, acquitted of two charges, and that double jeopardy bars retrial on those counts. And don't worry, we'll break all that down as we go through this in more detail. This petition thus raises the questions: can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper? This is so technical, but don't worry. Or constitute an acquittal where the jury did not announce or record a verdict in open court? We conclude that they cannot. The jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. Only after being discharged did some individual jurors communicate a different supposed outcome, contradicting their prior notes. Such post-trial disclosures cannot retroactively alter the trial's outcome, either to acquit or to convict. Accordingly, we affirm the trial judge's denial of the motion to dismiss and the defendant's request for a post-trial juror inquiry. So in short, what they're saying, and we'll go into more detail, but in short, what they're saying is Karen Reed wants to say that a few jurors have told her after the fact, you know, back when we were sitting there together as a jury, we decided on 2 of these counts. But they didn't decide that in open court. There was no ruling that way. And they're saying, you know, this is too late and there's no firm evidence that this actually occurred. So we're not going to let this undo what the judge has done, because the judge declared a mistrial on the whole case. The judge didn't say you're acquitted on second-degree murder, you're acquitted on the leaving the scene charge, and all you have left is this one charge for manslaughter. And that's what we'll talk about at the next trial. Instead, the judge just said, okay, mistrial, jury could not decide. We're going to go back into another trial. She immediately set a trial date. And they're saying, the Supreme Court is saying, we approve that. We'll talk about why. But first, let's go into what exactly happened. And I thought I might take us back to what actually happened during the trial. It was a lengthy trial, and the deliberations went on for a long period of time, starting for 19 hours before the jury came back. And here's what happened.
So, counsel, you're aware of our note from the jury. Dear Judge Canoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson.
So the foreperson sent this out, and the judge discusses it with them and says, she says, I want to hear from both sides. I want to hear what you think about whether this is enough. Have they tried hard enough to reach a verdict?
So I want to hear from counsel, your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
And they're going to say, let's keep going.
My answer would be no, Your Honor. This simply
Not
hasn't been
enough.
sufficient
Let's keep
time
going.
yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail.
So this is really important, and I'll let you hear a little bit more about what was said. But the defense, Karen Reed's team, said they've gone long enough. You could stop right now, Judge, and do the next step, which is to give them a TUI charge. We're going to talk a TUI Rodriguez charge. We're going to talk about that in just a minute. But at this point, the Commonwealth is saying, you know, no, 19 hours, given how long the case is, that's not enough. They should keep going. And the defense is saying, no, we think it's time to kind of call it and say, okay, this is not something they're ready to rule on yet.
Mr. Lally, I will hear you.
He's for the
Your Honor,
prosecution.
the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of TUI Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
Your Honor, I would disagree with Mr. Lally's
It's a defense.
characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last, 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is The jury should be read the Tui Rodriguez model instruction and go from there.
So let's talk about what the attorneys are saying. A Tui Rodriguez instruction is basically, well, it's also known as a dynamite charge. It's a charge to the jury that says it's supposed to put a stick of dynamite under the jury to blow things up and get things moving, to get the jury to go ahead and make a decision. So the judge says to the jury, and it's been approved by the Supreme Court, so it's used in virtually maybe every single state. And the judge will tell the jury, look, there's not a better jury out there. It's not like some other magical jury will appear if you can't decide. So, listen to each other, try to work together, try to make a decision. Let's go, get back out there and try again. And it's also important to think about why it is that you see the dynamic of the Commonwealth pushing for a verdict, and you see Karen Reed's team saying, let's go with the mistrial. Let's don't push them to reach a verdict. What Karen Reed's team is thinking is it's at least a close call on whether or not they're going to convict Karen Reed. It's so close that they may not be able to decide. And if there are enough mistrials and the Commonwealth becomes frustrated enough, maybe they'll stop bringing cases against Karen Reed. So a mistrial is way better than a conviction from Karen Reed's point of view. So she would a lot rather have that. And that's why her team is saying, no, let's just go ahead. Let's move forward. That's going to matter to the Supreme Court, this dynamic where the defense itself is pushing towards the mistrial in the direction of that. And they're saying, let's go ahead. So the judge says, well, I actually believe we aren't even to the level of giving that Tui Rodriguez charge yet. All I'm going to do is tell everybody, let's just keep working. I'm not going to consider this a true impasse because she only gets 2 before she has to stop if it's a true impasse.
Okay. All right. So you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
So the judge just tells the jury, no, nicely, and says, she gives them the, let's just don't decide while we're all hangry approach. Let's have some lunch. Let's just kind of relax a little bit and try a little bit more. She doesn't want to declare this a true impasse because you only get to give that Tui Rodriguez charge one time. You don't get to give it multiple times. She doesn't want to use it up yet. She'd like to save that.
All right, so jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations, all right? So I'm sending you back out.
So at that point, the jury came back in again. The jury went back out, deliberated, had lunch, and then came back again. Now, not 19 hours, but 22, 23 hours, another several hours of deliberation. And they say again, Judge Canoni, we really can't agree. Okay, so let's switch to the other video.
So, jurors, I am in receipt of your note. Judge Canoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds.
Now, notice that there was nothing in there about we can agree on some issues, we can't agree on others, we're able to reach these particular points together. Nothing like that. Instead, the wording used was deeply divided, fundamental differences in our opinions and state of mind, divergence in our views, not rooted in lack of understanding or effort, but deeply held convictions that each of us carry. Consensus is unattainable. That's what they said to the judge. So the judge then listens to both sides. The defense, again, wants to give the Chuy Rodriguez charge, the dynamite charge, and that is what the judge decides to do. At this point, the Commonwealth doesn't have a really great argument, so she goes with that.
Our view is that it's time for Chuy Rodriguez, Your Honor. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. The previous message said that they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Chuy Rodriguez is for.
I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due in thorough deliberation. So I'm going to give Chuy Rodriguez.
But even with that dynamite charge, after 4 more hours of deliberation, the jury still was at an impasse. And it was at that point that the judge declared a mistrial. Here it is.
All right, the jury is at an impasse. So we'll bring them in. All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt.
Okay, listen to that. Establishing the elements of the charges, plural. Okay. And actually, the Supreme Court didn't even mention that.
Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges.
Plural.
The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
All right. So let's pull out of that. And so that is what happened at trial. That is the circumstances, the course of events as the jury came back over and over saying they could not make a decision. And the Supreme Court is going to talk, Supreme Judicial Court, that's what they call it in Massachusetts, is going to talk about the meaning of that. And they're going to make a decision because after this happened, Karen Reed said, well, let's go ahead and read it. Let's go ahead and add it to the stage because here's what happened next. Let me pull this up. Okay. So I showed you the actual video rather than what the Supreme Court wrote. The judge and the parties remained in the courtroom to this is what you just saw, and here's what happened next. The judge and the parties remained in the courtroom to discuss their availability for scheduling a status conference on the matter. At no point during this discussion did defense counsel object to the judge's declaration of a mistrial or express disagreement with that outcome. According to affidavits submitted by defense counsel, a member of the deliberating jury, Juror A. So, okay, nobody objects. The defense has pushed for this mistrial. And not heavily pushed, but each time the jury came back, they said, yeah, it's time for Tui Rodriguez. So the judge then gets this final response from the jury saying, we're deadlocked, and it sounds really serious. It doesn't sound small or trite. It doesn't sound like we mostly agree, but there's a little bit different, a little bit of difference. It sounds like they really, really don't agree, and they've tried very hard. So at this point, the Supreme Court points out, well, the lawyers and the judge stick around, the jury is still back there, and nobody objects. Nobody says, well, judge, we should have polled them, or judge, shouldn't we find out if they agreed on some issues? Nobody did that. So at that point, there was just the mistrial, and that's where it ended until the next week, because the next week, the defense began to hear from some of the jurors. And this is what the Supreme Court says, a Supreme Judicial Court. According to affidavits submitted by defense counsel, a member of the deliberating jury, Juror A, contacted defense counsel. Juror A stated that the jury had unanimously agreed that the defendant was not guilty of count 1, murder in the second degree, and count 3, leaving the scene of personal injury resulting in death. Remember, neither side had any idea what the jury had decided. All they knew was they couldn't agree. And they made it sound, really, in the way they wrote the note and the plural on the charges, as if they didn't agree on anything. They fundamentally disagreed, guilty or not guilty, and it didn't matter what the charge was. But this juror is saying, actually, we were only down to one charge. We had already agreed not guilty on 2 of the 3. Well, now it's a huge difference for Karen Reed, because if she has to go back to trial, she would a lot rather have the only thing on the table be manslaughter, not murder, leaving the scene, and manslaughter. She'd really like murder off the table, because that is by far, the second degree murder charge is by far the worst for her. So, and then it didn't stop with Juror A. Juror B wrote it was not guilty on second degree and split in half for the second charge, which was manslaughter. An individual referred to as an informant by defense counsel was advised that another juror, and this would be Juror C now, had told friends that there was no consideration of murder in the second degree. Yeah, I'm going to make this a little bit bigger. That'll be better for me and you. There was no consideration of murder in the second degree, and that the jury deadlocked on the remaining charges. The exchange contained no mention of count 3, but it stated that manslaughter started polling at 6-6, then ended deadlocked at 4 no and 8 yes, which I assume means 8 guilty and 4 not guilty. So you can see already there are some differences in that they're not, some of them talked about that third count, some of them didn't. Some of them talked about different numbers as far as how split they were on that manslaughter charge, but everyone seemed to agree so far that it was a not guilty on the murder charge, that none of the jurors believed that it was should be guilty on second degree murder. They felt like it ought to be a lesser, lower charge. So that is huge for Karen Reed. But also notice this. It seems as if there were some significant number, we're not sure exactly how many, but some jurors who were leaning toward guilty, at least on manslaughter. So was it a good call for her lawyers to end the trial? Probably yes, because there is a good chance if it moved from 6-6 to 8-4, it evenly split to 8 who said she was guilty and 4 who said she was not guilty, then it was moving in a direction that was bad for Karen Reed. It was moving in a direction that could lead to her being convicted at least of that manslaughter charge. So it was probably a good call. The defendant argued that the account showed the jury had effectively acquitted her of counts 1, murder in the second degree, and 3, leaving the scene of personal injury resulting in death. She further contended that the judge's mistrial declaration was improper for these 2 counts and requested at minimum a post-verdict inquiry to confirm whether the jury had agreed she was not guilty of those charges. Defense counsel later supplemented the motion with accounts from 2 additional jurors. One juror, Juror E, stated that the jury had been deadlocked only on the lower charges on count 2 because that also was split out. The other juror, Juror D, stated that the jury's disagreement solely concerned count 2 and its lesser offenses. Juror D indicated that the jury had debated whether to inform the judge of their decision on counts 1 and 3, but they were uncertain if they were allowed to do so. And that is going to really be a problem from the perspective of the Karen Reed team, because they're thinking, okay, there was a decision on these, but the jury didn't know whether they could tell the judge, we decided on this, but we didn't decide on that. They didn't understand what the rules were. Juror D claimed that after discussing the matter, the jury ultimately decided to inform the court that they were deadlocked, and they expected they would get further instruction about the remaining decided counts thereafter. But that is, of course, not at all what they said. That is not what that note sounded like. The Commonwealth also submitted a post-trial filing notifying the court that after the submission of defense counsel's affidavits, it had received 2 voicemail messages from a member of the jury. The juror specified that the jury had voted not guilty on counts 1 and 3, and as of the last vote, 9-3 guilty. Again, another number. We've had 6-6, we've had 8-4, and 9-3, but it's moving in the direction of guilty. So again, was it a good call by her defense counsel to pull this? I would say yes, to push for the mistrial, because there well might have been a conviction of manslaughter. Of course, there could be the next time around, and there also could conceivably be a second-degree murder charge in the next trial. The Commonwealth also received email messages from 3 individuals who identified themselves as jurors and asked to speak anonymously. Once the Commonwealth informed them that it may be required to disclose the substance of their communications to defense counsel or the court, however, the jurors declined to communicate further. So now now we're going to get into what exactly was said by the Supreme Court. Why did they rule the way they did? Why did they rule that Karen Reed has to go back and face a trial on all counts? None of them are going to be removed under the theory that the first jury already decided those. And here's what they start off with. What's the rationale in general for doing this? And it is the double jeopardy clause of the Fifth Amendment to the United States Constitution generally precludes the Commonwealth from trying a defendant more than once for the same offense. So the Commonwealth gets one shot to convict a defendant, and if they can't, then they have to move on. They can't keep trying the person over and over again, but there is an exception. An exception to this general rule applies when a mistrial is declared due to manifest necessity. Now, you might argue that a hung jury isn't that, but you would be out of luck, because it has been decided that a hung jury is recognized as a, quote, traditional example of that. And the decision will be made by the judge in the judge's sound discretion. What does that mean? That means the judge gets to decide, and no one is going to second guess the judge. No one is going to say, Judge, we are going to look very closely and carefully, reviewing all over again the reasons that the trial court made that decision. Instead, the appellate court is going to look at it and say, okay, this particular decision was made by the trial court. We're going to assume they did a good job, that we're going to let them make the choice. They were there, they saw what was happening, and we're not going to undo that. So it's very hard when an issue is left to the sound discretion of the trial judge. It's very hard to get the appellate court to overturn it, because there's a high presumption that the trial court did the right thing. In evaluating whether a trial judge abused his or her discretion in declaring a mistrial, a reviewing court considers whether the judge carefully explored alternatives to a mistrial and whether counsel was given full opportunity to be heard. And so that's where all of those times that the judge sent them out, that would count as alternatives, where she kept trying to get them to resolve it. Whether counsel were given full opportunity to be heard, that one is a little bit more controversial, because Karen Reed's team says, well, you should have asked us before you just said, okay, here's the note, you're gone, goodbye. You should have said, what do you think, counsel? You did that the other 2 times, but you didn't do that the 3rd time. So I think the judge wasn't required to do that. And but as far as full opportunity to be heard, the Commonwealth and the Supreme Court said, the Supreme Judicial Court said that you were given the full opportunity to be heard because you were standing there and you didn't say anything to the contrary. Here we discern no abuse of discretion in the trial judge's decision that the jury were at an impasse and that a mistrial was manifestly necessary. After extensive multi-day deliberations, the jury submitted several increasingly increasingly emphatic notes about their inability to reach a unanimous verdict. So, and they're going to go through and catalog each of these. We've done that, so I'm not going to go into detail about that. And I want to say thank you to Mathis. I appreciate that and letting me know. I really do appreciate when y'all let me know about anything that happens in the cases that we're covering or that you're following that interest you. So please do let me know about that. If you know of a hearing coming up, if you see a document that gets posted online, I would love to get that. Thanks. Okay, so first, there was that first note from the jury. Then the second note further emphasized that the deadlock arose not from a lack of understanding or effort, but from deeply held convictions that each of the jurors carried. And then she gave the Tui Rodriguez charge, the dynamite charge. It didn't work. After nearly 4 hours of additional deliberations, bringing the total to approximately 28 hours, the jury submitted a third note that was even more emphatic, and it was. Nonetheless, the jury argues that the judge should have inquired whether the jury had reached agreement on any of the charges. And they're going to say, okay, if they're going to argue, the Supreme Judicial Court is going to say, no, actually, she shouldn't have done that at all. Here's what they say. The trial judge has discretion to require a jury to return a verdict for charges on which they have unanimously agreed before declaring a mistrial. So it was up to her, and she picked no. So it's discretionary. It's up to her. We're not going to look into that or second guess the decision she made. A judge is not required to accept a partial verdict before declaring a mistrial. So she didn't have to do that. That's the rule. The trial record offers no indication that a partial verdict was imminent or possible. In fact, the jury's third note implied they were deadlocked on all charges. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges, plural, beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges, again, plural. And so that note is part of the reason why the Supreme Judicial Court is going to say, look, we believe the jury gave her every reason to the Judge Cannoni, every reason to believe that they had done everything they could and that they were entirely deadlocked, not just deadlocked on one charge, fully in agreement on the others, but just entirely deadlocked. And so, and they're going to say that. The first and second notes, in short, the record before the trial judge suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. Additional inquiry into the jury's deliberations risked producing a coerced verdict. And we'll read the next couple sentences, and then I'll explain a little bit more about what they're talking about. Judges must carefully avoid actions that might pressure jurors into compromising their genuine views of the evidence. It is precisely for this reason that judges are statutorily prohibited from ordering further deliberations by a deadlocked jury that has twice reported being at an impasse after due and thorough deliberation, unless they explicitly consent or seek clarification on the law. So here's what they're saying. If you went back if the jury comes back and says, we really can't decide, and the judge says to them, come on, we've been here for weeks. Can't you decide on one or two? I mean, decide on something, right? I mean, are you deadlocked on every single charge? And even if it's a lot more formal than that, and the judge simply says, as you know, we would like to resolve this if possible. Is there anything you can decide? They're saying inherently that's going to put some pressure on the jury to come up with some conviction, any conviction. And that's why I think Karen Reed's team wasn't pressing for something like that. And it was wise not to, because notice some of the jurors think it was 6-6, some 8-4, and some as far as 9-3 in favor of guilty on that manslaughter charge. And that would have been the pressure on them. Like if the judge had said to them, is there anything you can decide on? That might give the jury the idea that they need to go ahead and find some common ground, convict her on something. And so they don't want that. They feel like that would be unfair to defendants. The risk of coercion is also heightened when a judge inquires about the possibility of a partial verdict following a deadlock. The jurors are confronted with the request and asked to absorb its inherent complexity at the worst possible time, when they are tired, anxious to be discharged, and perhaps angry at fellow jurors whom they blame for failing to reach agreement. So in general, that's not what a judge should do. And so the Supreme Judicial Court is saying, no, we don't agree with that at all. After receiving the third note, the judge was statutorily, by statute, by law in Massachusetts, barred from ordering further deliberation without the jury's consent. Give me just a second. Far from suggesting that consent might be obtained, the third note made clear that further deliberation would only serve to force the jurors to compromise deeply held beliefs, rooted in sincere adherence to their individual principles and moral convictions. Why do we say that? Because that's what the jury said in the jury note. Asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial. And typically defendants would not want that. If the judge had inquired about a partial verdict on her own initiative and the jury returned a verdict of guilty on any of the counts, there is no question that this defendant would be making a strenuous and potentially meritorious argument that that guilty verdict was the product of coercive intrusion into the function of the jury. For much the same reason, the trial judge's decision not to poll the jury, sua sponte, that means on her own accord, to confirm the deadlock before declaring a mistrial did not constitute an abuse of discretion. As we explained in another case, polling jurors about whether further instructions or deliberation would be likely to resolve the deadlock is discouraged due to the risk of coercion. So, and it does say in questioning jurors, particularly in individual colloquies. So in other words, it's bad enough to ask the jury and kind of pressure them to make a decision. But if it's one-on-one, like, what about you? Did you also refuse to agree to anything, Joe? If the question is perceived that way, even if it isn't really said that way in court, they're saying that could be really coercive and force people to make decisions and compromise their beliefs, which typically would hurt the defendant. The judge explained that she had previously sought defense counsel's views after receiving each of the first two jury notes when counsel had argued that the jury were at an impasse. The only alternative proposed by defense counsel was that Tui Rodriguez charge we talked about. And then she declared the mistrial, and they never objected. There was no objection from the defense. So, and after that third note, the judge was no longer, by statute, allowed to send the jury back out. They had to request, and that wasn't happening in the context of what was happening in the courtroom. So while the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, the trial judge did not abuse her discretion in failing to do so. So this is kind of like, this is criticism a little bit from the Supreme Judicial Court of Judge Canoni. It's not heavy criticism. It's saying, well, okay, Judge Canoni would have been a lot better off if when the third note came in, instead of just reading it in front of the jury and then dismissing them right there, if she had said that, thank you for your note, and read it privately with the attorneys, gotten arguments from both of them, almost certainly the defendants would have said, let's stop there. We don't want to keep going. At this point, they've said they can't decide, so let's leave it there. And that would have been a wise choice by the defendant. And that's probably what they would have said at that point. They wouldn't have had this ability to have this appeal. The appellate court is saying, okay, yeah, probably that's what you should have done, Judge Canoni. But, it's not a huge deal. In the context of all that happened here, we don't believe it's a huge deal. So there was a separate argument that the defense made, that Karen Reed made, that she couldn't be retried because the fact that she believed it ought to be considered an acquittal. The fact that some jurors say that all the jurors agreed on counts 1 and 3, that ought to be considered an acquittal, even if it wasn't. And the court made pretty short shrift of this argument, said that, look, the way the double jeopardy clause works is you can only be tried once for an offense. And if you're acquitted for that offense, then you can't be tried again. But acquitted means a jury verdict that's unanimous and returned by the jury to the judge in open court. And that never happened in this case. They also said that it's undisputed the jury did not announce a final verdict on any charge. They never did in court. And think of the problem it creates if you try to bring the jury back in and have them discuss what were you about to decide, because they may disagree. And then what do you do? And even if they do agree, they've been subject to outside influences for months on end. They're not the same sequestered or protected jury that hasn't seen anything or known anything. By now, they've seen everything in the media. And and they talked about that. You don't want to bring jurors back in and talk to them, because you want that verdict and everything they say in the jury room to be private, so that reflects unanimous and deliberate judgment of each juror, not under public scrutiny. I'll go ahead and read it. Requiring a jury to publicly affirm their verdict in open court thus serves a vital purpose. It ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny, rather than a tentative compromise. So in other words, what if that wouldn't have held up? Would they really come out in the courtroom and have said that? Or was this just something where they were kind of agreeing in the back room? And then they also say, because one of the things that Karen Reed's team, sorry, I'm having a hard time here. So one of the things Karen Reed's team said was, well, let's at least bring all the jurors back in and let's ask them, because do they agree? If they don't agree, okay, well, maybe we move on. But if they do agree, this is a pretty important point. We should at least ask them. Said, finally, we considered the denial of the defendant's request for a post-trial juror inquiry. Generally, a judge is not obligated to investigate jury deliberations unless there's evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. They say, well, that didn't happen here. There's nobody arguing that happened. So instead, I'll read the last sentence. Last couple. A verdict as a matter of law requires a public announcement in open court. No verdict exists if none was announced. And they don't want them looking into the jury and asking them questions about what they decided. Additionally, the limited exception for juror testimony concerning mistaken verdicts only results in alteration of a verdict where there has been no opportunity for outside influence. And that's not the case here, because it's months afterwards by now. A post-trial inquiry of these jurors would similarly occur well after they became susceptible to outside influences and would not provide a recognized basis for altering the result of the first trial. So, all right, let's pull out and talk about what we just read. So what they are saying in this opinion is that we don't see any reason to either bring the jury back in or to declare that there is that certain of these were decided because it's just not reality. They were not decided in open court, subject to scrutiny of the public. That didn't happen, so we're not going to count it. This is definitely a blow to Karen Reed because I think they would have loved to have gotten those 2 charges out, those, especially that second-degree murder charge. It would have been fantastic to have gotten that out. But I don't think it's a surprise at all. The fact that the jury was already gone made it really impossible for the judge to do that. The judge could not, there had no way to confirm that these jurors had made that decision, and without bringing them back in, conducting inquiry into what they were deciding in the courtroom, that or in the jury room, that's not allowed. So there really was no possibility, I don't think, that this was ever going to be granted. However, it's super important. The fact that the jury was leaning against murder, was leaning against the fleeing the scene charge, that tells everybody something about the next trial. It tells everybody they need to look hard at the manslaughter, because that's where the jury was leaning toward. If we listen to the majority of the jurors, they had different numbers, but the majority of the jury was leaning toward convicting Karen Reed on that manslaughter charge. And so that should be a real focus of the next trial, not just the who else could this have been, and was this Karen Reed at all? That was part of it, but they also need to look at the manslaughter and what exactly are the reasons that might have convinced the jury that she might be guilty of manslaughter. And that's where the focus is going to have to be. So it's going to make a significant difference. I'll take some questions. I want to say a shout out to the first 5 in the chat tonight. Denny, this afternoon. Denny, Oklahoma Gigi, Teresa, Starling, and Jennifer Wren. Special shout out and welcome to all of you. And I'll look for question marks at the beginning, and that'll give me my clue that that's your question, because in the chat it can sometimes get lost. So one of the things I think that people will be interested in knowing and looking at in this case is, does this indicate any sort of view that the Supreme Court has of the job that Judge Canoni is doing on the case? I don't think it necessarily reflects broadly, we think she's done a great job, but it clearly does reflect that they think she made reasonable choices in this context. And I think that's going to be significant moving forward. So I am not seeing it. What we'll do, it's a special pop-up live, so I know we've got a smaller group than usual. Thank you all for being here. Carrie, if Karen Reed admits to asking aloud, did I hit him? Isn't it possible that she did hit him and didn't realize it? Would you recommend the prosecution use this in their arguments? I think that they focused on the murder because that's where they wanted the charge to go. That may have been a mistake. I think it was overcharged. There wasn't a lot of evidence that would really support that. The manslaughter, it could be they could convince the jury that she did hit John and didn't realize it, in which case they could be looking at the manslaughter charges. So will they focus on that more this time? Maybe. It sounds as if they almost hooked the jury last time. They had at least some jurors who were with them on guilty. Anywhere from 6 to 9 of the jurors, depending on which of the post-trial juror statements you believe. Why do judges seem to lean in favor of the prosecution? Asked Mel Stiller. You know, that is such a good question. I can't answer. I think it may be for the same reasons that the public tends to lean that way. The belief that, you know, the prosecution is not there for funsies. It's not fun and games. They're there because they believe somebody committed a crime and they believe they have evidence to back that up. And so I think typically there's a presumption that that's why we're all here. But that isn't how our system is supposed to be set up. We're supposed to be set up with the presumption of innocence. It's just very hard in reality to do that. That's not an easy concept because here you have a defendant. I mean, if you're told that the defendant sitting there in front of you, you're a prospective juror, and the defendant who maybe even looks menacing, and you're told this is a person who murdered multiple people, someone who did terrible things, could you convict them of all these things? And and they walk next to you, you're going to be a little bit afraid. That's kind of, I think, how it is with the public. And maybe that's part of the reason. A second reason, though, is that judges are often former prosecutors. So that's something they have a past doing. And that's sort of the perspective from which they come. So Margaret Maddox wants to know, is there an ineffective counsel argument for the defense not polling the jury before the mistrial? In theory, maybe, Margaret, because I mean, they probably should have asked for that quickly, but the Supreme Court has ruled that it was in the discretion of the trial court. She didn't have to listen to them, didn't have to do anything different. And so I don't think it would be a winning argument because of the way the Supreme Court ruled here. I think that they would just say, you know, look, that was discretionary and there was no, it wouldn't have done any good for the defense to have objected. So I believe that would be how they would ultimately rule. Verified Vegan, do you feel the jurors were confused by the instructions, and should they at least ask the jurors that for future jurors? So this is Verified Vegan. I feel like this. If the jury in fact can return one of three verdicts, and that's fine, you don't care, you want them to decide all three, but if they decide two, that's close and you'll take it. I think they need to know that at some point. I think there needs to be a charge that says, you know, return a unanimous verdict. It was something like, you know, you must reach a unanimous verdict. Okay, yes, but if it's you must reach a unanimous verdict for each of these counts, let us know on any one that you can't reach a verdict on, then that would be a different thing that you're requesting of the jury. And that's not the way the charge reads or the way the charge is done. All right. Well, I will see y'all tomorrow night at 7 p.m. Eastern. If you would, I always forget, would you like the video? That would really help it get out to more people. And subscribe. We would love to have you back for more. Thank you so much. I know that Marlon and Denise were able to come at the last minute. I'm very appreciative to them for doing that. And I will see y'all tomorrow night.